Imagine a father in his kitchen at midnight. He walks past the bedroom. His service weapon sits on the top shelf of his closet, unloaded, no round in the chamber, magazines separated and clipped to the frame. He did everything the way his father taught him. He thought he was being safe. He thought he was being a responsible gun owner in his own home. Then the door opened. Two officers stepped in with a warrant they did not have to read to him, and what he thought was a private choice became a criminal file. They never told him the rules had changed. He was not arrested for what he owned. He was arrested for how he stored it. Everything changed in minutes. This came out of a stack of real cases, and the laws behind them are not obscure. They are already on your books. One small mistake, and now he is the one paying for it. Before we go any further, do something for your family right now. Hit that subscribe button and turn on the bell. Not because we are chasing a number, because every alert like this one is built to put a piece of knowledge on your side before you ever need to use it. Think of it as information defense. When the next statute hits, you will have already seen it here. Here is the trap almost nobody sees coming. You believe you have a right to keep a firearm in your home. That part is settled law, and it is not opinion. The Supreme Court of the United States ruled in District of Columbia versus Heller, 554 U.S. 570, decided in 2008 that the Second Amendment protects an individual right to keep and bear arms in the home for self-defense. That is the win. That is the shield. But here is what most clips never read out loud. In the same decision, the court also wrote that this right is not unlimited, and that long-standing lawful regulations, including rules about how firearms are kept, were left on the table. Translation for a regular American: you can own the gun. The state can still tell you how you must store it. That two-reality collision is the whole story. On one side is your home, your bedside, your family, your right to defend them. On the other side is a stack of statutes, agency rules, and prosecutors who have been charging safe storage cases like clockwork. They do not have to take your gun away. They just have to call the way you stored it a crime. Let me walk you through the 7 categories that are putting law-abiding gun owners in handcuffs in their own living rooms, and I will use only the wording that real courts and legislatures have used. No hype, no scare quotes. The first category lives in California, and it is called criminal storage of a firearm. California Penal Code 25,100 makes it a crime to keep a loaded firearm anywhere on a premises you control if a child under 18 could access it without permission, or if a person who is prohibited from owning a gun could get to it. A first-degree version applies when a child actually gains access and carries it off school grounds or to a public place. The penalty ranges up to potential felony exposure. The new layer came when Governor Newsom signed Senate Bill 53 in 2024. Beginning January 1st, 2026, California will require every firearm in the home to be stored in a Division of Justice-approved locked container or with a compliant device. The phrasing the law uses is securely stored. The second category sits in Massachusetts. Massachusetts General Laws. Chapter 140, Section 131L makes it unlawful to store or keep any firearm, rifle, or shotgun in any place unless it is secured in a locked container equipped with a tamper-resistant mechanical lock or otherwise made inaccessible to any person not authorized to possess it. The statute does not require a child to be present. It does not require an accident. The violation itself is the crime, and a conviction can carry up to 18 months in a house of correction and serious fines. The third category is the wave of child access prevention laws spreading through the country. According to RAND's analysis, as of January 1st, 2025, 35 states plus the District of Columbia had some form of CAP or safe storage rule on the books. Michigan's new secure storage law took effect in 2024 after years of public debate. New Mexico and Vermont laws took effect in 2023. The point is not the geography. The point is that the rule that used to live in one or two coastal states is now the rule of the road in more than half the country. The fourth category is the Federal Child Safety Lock Act reference inside 18 U.S.C. Section 922. Federal law defines a secure gun storage or safety device and writes it directly into the statute at Section 921A.34. Translation: the federal government itself recognizes a duty to store firearms in a way that prevents access by unauthorized persons. This is the language agents and prosecutors borrow when they file a case. The fifth category is the household composition rule hidden inside these laws. Many of them turn on who is in your house: a roommate with a restraining order, an adult child who tried to buy a gun and was denied, a grandchild visiting for the weekend. If a prohibited person can reach your firearm, your storage may not satisfy the statute. Even if the gun is in a case with a padlock, someone with a screwdriver could pop. That is the trap door. The firearm is stored. It is just not legally stored. The sixth category is the loaded versus unloaded distinction. Several statutes, including California Penal Code 25,100, treat an unloaded firearm more leniently than a loaded one, but several others do not. Massachusetts does not hinge on whether the gun is loaded. It hinges on whether it is locked. Owners who think the chamber empty trick saved them have been charged anyway. The seventh category is the everyday visitor problem. Police do not need probable cause to knock on your door. They do not need a warrant to ask how your gun is stored. If they walk in with consent, yours, a roommate's, a guest's that you did not overrule, what they see in the closet becomes Exhibit A. That is exactly how a clean, lawful home becomes a courtroom. So here is the emotional turn. Most people watching this think the safe storage rule protects them. They hear the word child in the statute and they think it is about other people, about the messy home down the street. Do not make that mistake. That is where people lose. The rule applies to you. It applies to your gun. It applies to your drawer. And prosecutors have been filing these cases against owners with no criminal history, no reckless behavior, and no harmed child. Here is the survival protocol. Run it tonight before you close the door on this video. First, locate every firearm in your home: closet, nightstand, drawer, safe in the garage, heirloom in the attic. Do not skip the one your spouse keeps. Do not skip the one your adult child left behind. Every one of them is now part of the case. Second, identify your state. Pull up your state legislature's website and search safe storage, child access prevention, and criminal storage of a firearm. Read the statute yourself. Do not rely on the guy at the gun counter. Third, buy a real locked container that meets your state's definition. If your state defines secure by a specific standard, California lists DOJ-approved devices match that standard. If your state says locked container, treat that as a sturdy, bolted, or cable-locked unit, not a zippered soft case. Fourth, store every firearm unloaded with the magazine or cylinder removed or rendered inoperable and put the ammunition in a separate locked space. Fifth, document your setup. Take a phone photo of the locked container with the firearm inside and a timestamp. Date stamp it. If a case ever opens, this is your proof. Sixth, lock down the people problem. If a prohibited person lives in, visits, or works in your home, that single fact can override every other step. Talk to a lawyer in your state about how to comply without breaking other rules. Seventh, never consent to a voluntary search of your home. If officers ask, say clearly that you are not waiving your rights and you want to speak with a lawyer, politely, firmly, without argument. That is the protocol. 7 steps, none of them political, all of them legal. The takeaway is simple and it is final. You still have the right to defend your home. The safe storage case in 2008 and the wave of state laws since then have not erased that right. What they have done is add a technical layer that trips up good people. The layer is real. The cases are real. The arrests are real. Your job tonight is to make sure your home is not one of them. If this video helped you, Share it with one gun-owning household you care about. That is how information defense works. Subscribe and turn on notifications. We will see you on the next alert.